transcript issue?
Sure. With respect to the transcripts, in that this is the zoning hearing board's review of the underlying proceedings as far as what was under consideration both by the Bethlehem Planning Commission as well as City Council. What we did was make a right-to-know request, and we requested all the audio recordings of what are 4 separate proceedings. The first being the November 8th Bethlehem Planning Commission meeting. The second, and that's exhibit 25 in this another notebook that I'll give you. Exhibit 26 is the November 20th, 2018 hearing on this subject amendment. Exhibit 27 is the Bethlehem City Council meeting on December 4th of 2018. Exhibit 28 is the December 18th, 2018 final vote meeting before City Council. We obtained all of those audio recordings of those proceedings, and we transmitted them to Veritech's court reporting, and they transcribed all of those in their booklet form. And they have all the testimony of the various witnesses on both sides. And I'm suggesting to submit the complete transcript, not just what's cherry picking what's favorable to the appellants, but the complete transcripts for this zoning hearing board's review and consideration to make it a fair determination as to whether or not the subject amendment is valid. So that's the basis of the request. To the extent that there's objections on authenticity, I've asked Mel Bartman to be here to do the chain of custody of the audio recordings, the transcription, and the creation of these 4 transcripts. So I'm prepared to do that if we need to go down that path. But on the basis of expediency, convenience, I submit that this will streamline these proceedings and hopefully shorten this quite a bit, because there are a number of witnesses who we will not need to call, in particular the Bethlehem Planning Commission witnesses that we intend to call. We would just rely upon what they said at that proceeding. And similarly with certain other witnesses, and we can condense this proceeding if this board would accept these transcripts.
Okay, so a question for the witness you brought, Ms. Bartman, would testify that she took the tapes that were the tapes the city provided you, and what's in those is perfectly accurate or virtually identical to what was on those tapes, to the best of her ability, right? Because I'm sure there's words you couldn't understand, but okay. And then your position is those are identical. Instead of calling the witnesses, you'll have the transcript of the 4 meetings, and you would say, I believe they're relevant to the underlying matter that you're going to decide, board. That's why I want to submit them. So there's really 2 issues. Can we do it by transcript, and is the transcript even relevant? So,
okay.
So I guess.
Can I just respond to that?
Yeah, go ahead. I'm just trying to figure out what we're, so that when they answer, I know what we're talking about.
Great. I mean, it's beyond relevant to the extent that this is the actual transcript. These are the actual words. These are references to exhibits. These are the memos of Darlene Howard, references to the memos of Darlene Howard. You know, as it occurred real time for this board to review, as opposed to a proceeding here where piecemeal will be pulling in, witnesses and trying to recreate what was before both the Bethlehem Planning Commission and then City Council to make the determination of the passage of this amendment. So my submission is I submit that this is really the best evidence of what this board really needs to review and consider in its determination as to whether or not what council did in passing this amendment was correct. To the extent that there are certain witnesses, and similar to how we do it when, say, it's a zoning hearing board matter that we appeal to the common pleas, there may be a need to call certain witnesses to amplify certain matters, to clarify procedural issues, and I'm prepared to do that. And I do have a few hand-select witnesses who I intend to call to do that, and then that's really for the board's purpose to really hash out and clear up certain issues that we're saying are certainly critical for our invalidity challenge to the amendment. I have a number of some case law and precedent that I'd like to make. If you're going to turn it over to the other side, I want to make sure
Okay.
all of that's supported.
Why don't you just summarize what those are and then hand the cases up and hand them to council?
Okay. The other key principle in this board's consideration for the admissibility of the transcripts is the section in the MPC, section 53 PS 10908, section 6, which states that administrative agencies such as the Zoning Hearing Board are not bound by the technical rules of evidence, and all relevant evidence may be admitted. And on that basis, under the MPC, the more lenient standard for evidence, we'd ask that this board submits as evidence the underlying transcript. I am anticipating, because this is the phone call that I had from the city solicitor, that the city solicitor's argument is going to be that he objects that he wasn't present at some or all of these proceedings, and he would need a fair opportunity to cross-examine certain witnesses. The appellant submit that that's not a valid objection in the context of a proceeding where it's a public hearing for the consideration of a zoning amendment. The rules were set forth for this proceeding by Chairman Waldron, and he set it forth where he gave the applicant a period of time to make their presentation. Darlene Heller, City Planning, gave her presentation. City Council then had their opportunity to ask questions, and then each witness from the public was limited to their 5 minutes. There was no opportunity to cross-examine any witnesses, so that challenge to these transcripts is invalid because it couldn't have been done in the first place. Furthermore, there is authority to support that, and that is the Perrin case, which we're both actually referring to, but I'm referring to for the important proposition that there is no right to cross-examine in this type of proceeding, and therefore that's not a basis to object.
You say in this type, you're not referring to tonight, you're referring to...
I'm sorry, I'm pointing to the transcript, but I'm talking about the City Council's consideration of the amendment. The other point is there are references in the transcript to exhibits, which are in your notebook as well, all the exhibits that were submitted during the course of these proceedings. It's our position, whether they're letters from interested parties, whether it's a memo from Darlene Heller, those references and discussion of those memos is not deemed inadmissible hearsay in the context, this context of a consideration of a proposed zoning amendment. And the case that I have, and I'll hand that case out, and it's the Appeal of Benich case. If I can approach it.
Sure.
And I've highlighted the relevant portions of this disease.
Thanks.
In that case, it was a positive case for the appellants in that the zoning amendment that was being considered was deemed invalid spot zoning. The key component of the case, I think I handed my copy. Did you get an extra one? Yeah, sorry. In there, the underlying record to the challenge to the zoning amendment in this particular case, a consulting engineer simply submitted a report, and that was relied upon by the governing body to make a determination as far as the zoning amendment. When that went up in appeal, it was a challenge saying it was inadmissible hearsay, but the court ruled, the Benich court ruled that that was a valid report, the written report was valid and could be considered because it was made a part of the record. So to the extent that there's any kind of reports or references to memos, what would typically be hearsay, because it was made a part of the underlying record and it was before City Council in their consideration of the amendment, then it's not considered an inadmissible hearsay, and that's another reason to submit the transcripts in this circumstance as evidence in the case.
Which headnote are you referring to?
It's not a headnote, it's a footnote. In the body of it, it's footnote 5. In the body of it, it's in that section 5. the court reached the finding by accepting the opinion of Fawn Township's consulting engineer in that section, and then it refers to footnote 5 of the case, which talks about.
So you're suggesting that that we have to, or the court in here had to consider what the consulting engineer's opinion was?
I don't know if it goes that far. What I'm saying, I'm giving this zoning hearing board comfort that you can take this the transcript as well as what's in the notebook, which is going to be arguing in just a few minutes, the exhibits that were submitted to City Council, and consider memos and what would typically be considered hearsay because it's part of the underlying record. And you have comfort in doing that based upon the defendant's case, because in that case, similar situation, there was a consideration of a zoning amendment. The report of the consulting expert was simply submitted as a letter report that was relied upon by the governing body. When it went up on appeal, they said, that's okay. And it's not inadmissible hearsay, you can consider it.
So the board could have decided here not to consider the opinion of the consulting engineer.
Perhaps that could have been the case. I mean, I think you have wide discretion, quite frankly. I mean, to consider, relevant evidence, and I think you have that consideration. I mean, you could do both. You could, admit the report, but if you really feel a strong need, you really wouldn't want to hear from a consulting engineer live and have whoever's producing them, the applicant or the appellant, to have them live. Okay. The next argument is it's Exhibit 20, and you guys, before they turn to Exhibit 20, if you want to take a look at this, is a letter that I sent to Attorney Spark, the solicitor for City Council. The letter is dated December 12th of 2018, and this, timing-wise, you have the timeline. We had the first vote at City Council on December 4th of 2018. After that hearing, and after hearing the input from City Council and how they were voting, I sent a letter, the letter that's Exhibit 20 in the notebook, to Attorney Spark, and made a specific request to admit as part of the permanent record the 14 exhibits that I had already at that point handed up to City Council for their consideration up to that point. So I was creating a record to make sure I had already handed all these exhibits that I'm referring to in this letter to City Council, and it was before them for their consideration before their vote on December 4th. Just to be doubly sure and to make sure it was going to be made a part of the record, I followed with this letter to Attorney Spark asking him to make it a permanent part of the record.